Okay, I'll go ahead and get started and people can rejoin as they will. Um, so, an ironic name for our next topic, considering what we just went through, but winging it. Um, a lot of my clients come through the door and they've been operating in their business for a few years, and I find out they have no contracts in place. No contracts with their customers, with their vendors, with their employees, independent contractors, partners, etc. Um, just they've been operating either on handshake deals or using something that they pulled from the internet that's about half a page long and doesn't really say much of anything, or worse, it says something that they don't really intend to say. And I always get the question, why do I need them? I've never had any problems with my customers, vendors, employees, contractors, partners before. And my job as an attorney, it's not to promise people what's going to happen, because I can't promise you anything. It's possible that you can go 30 years in business without an issue, despite having terrible contracts or even no contracts. You might be lucky. But my job is to kind of provide my clients with some examples of the worst case possible outcomes if they go that route. So let's have a look at what those are. Without a contract, for your business that you would have with customers, your customers can, and here's just a few examples, they can refuse to pay you in full or in a manner you consider timely because they dispute what they agreed to pay you or when they agreed to pay you. They can deny that you provide the goods or services in the manner they expected, because if you don't put this down in writing, what you're going to provide and when, it's up to interpretation. It's up to whatever their understanding was, because contracts are about a meeting of the minds. It's about two parties, well, minimum of two parties, coming to an arrangement where they both have an understanding, a mutual understanding of what each party is going to do for the other. And so, they can deny that you did what they expected you would do. Even worse, in some cases, they can deny that a contract exists after you've performed under it. Because there's no written contract, they can say, well, we didn't really have a meeting of the minds, so there's no contract. Thanks for everything you did, but go away. And then you're left holding the bag and fighting it out in court over what's called quantum meruit, which is a fun Latin term for basically the value of work provided. If you don't have a contract, you at least get to get paid the value of what you did. But those lawsuits typically are so expensive that no one sues under them, because what you'll recover is often a lot less than what you spend on the lawsuit. So you could be left holding the bag after you've performed and the other party decides they're not gonna. They can claim that you breached, and this is a big one that no one, I swear no one knows about. There's these things in the law called implied warranties. Basically, if you sell something, it is implied that you're warrantying what you sell in at least two ways. Merchantability and fitness for a particular purpose. You're warranting that what you're selling them can be sold or resold, as the case may be, or that it's fit for a very specific use case, fitness for a particular purpose. If you have ever signed a purchase agreement, there's like a 90% chance you've seen in big capital letters somewhere in the bottom third of the document, disclaimers, express disclaimers of the implied warranties of merchantability and fitness for a particular purpose. And there's a reason for that. And the reason is these warranties are vague, they're nebulous, and they rack up over time. So the more you sell to more customers, the more implied warranties you have out there that you could be called upon to honor, even though you didn't know you were providing any warranty at all. And some of those warranties, like merchantability, if they turn around and can't resell it in the way that they expect to, they could turn around and hold you liable for that. So have a written agreement with your customers that even it needs to do the bare minimum. It needs to say who's providing what. Party A is providing goods, party B is providing money. They're going to do it on this time frame and in this manner. These implied warranties are disclaimed. This is what the actual warranties are, if any. This state's laws apply. If there's any lawsuit, it has to be brought in this court. The winner gets attorney's fees. This agreement can be signed in one or more parts. It can be delivered electronically. That's fine. There's some basic framework for an agreement that you should have in every customer contract. It doesn't have to be complicated. I've done this as a 2-pager, which is basically the front page is the purchase order and the back page is all the terms and conditions. Small print, but it's doable. But having nothing just really opens yourself up to a litany of problems. But then let's look at this in other contexts, because let's say you're hiring independent contractors. If you don't have a real contract, this can get really thorny. And I mean, really thorny. Because for one, obviously they could claim that you're not paying them what you agreed to. They could also claim that you agreed to hire them as employees, not as independent contractors, especially once tax and rev goes after them for gross receipts tax. Because fun fact, if you're providing services in New Mexico as an independent contractor, tax and rev considers you your own business, and they will charge you gross receipts tax on the revenue you get, even if you're not passing that tax on to your customer. And so if you are hiring independent contractors and they don't pay their gross receipts tax because they don't know about it, and then the state goes after them, one of the most common things that they will do after talking to an unscrupulous lawyer is claim to the Department of Workforce Solutions and the Department of Labor that they were in fact misclassified employees. And so having a good contract spells out the relationship. It says, no, you're not an employee, you're an independent contractor. And it also makes sure that you spell out in the contract all the things that you need to do to keep them independent contractors, because there's a whole set of rules about that. But if you don't have a real contract with them, who knows how that dispute's going to work out in front of a Department of Labor board that is very employee friendly, notoriously so. And so you're protecting yourself with the contract. Again, there's the other basic stuff. You don't want people to be able to sue you in another state or apply another state's laws. You don't want them to be able to create liability for you or your company that would otherwise be assumed by the independent contractor. You want them to be responsible for the work they do. You want them to be responsible for getting insurance to pay, if they do something bad, someone gets hurt, they need their own workers' comp policy, liability policy, etc. That can all be contained within a contract. And so you should have one. Business partners, if you don't have contracts with your business partners, this is another thing we see a lot. They can claim ownership percentages, voting rights, rights to profits or losses above what they're really entitled to. If you don't spell it out on paper, they're going to make a claim if they're unscrupulous for way more than they're entitled to. They can try and hold the business hostage to whatever demands they have that the business do or not do something. They might even try and directly compete with the business if there's nothing in writing saying that they can't. So you should have a contract with them. Vendors provide the contracts most of the time, but still important to have one so that everyone has reasonable expectations of what's going to be delivered, when, for what cost, how the vendor can or cannot increase prices, how they can use proprietary information learned from you, or how they can't really. I mean, it's a lot of nitpicky stuff, but it's stuff that you never really think about until someone does something that seems horrible and unjust and unfair and wrong, and you start looking for relief, and then you realize, hey, I have nothing in writing saying they can't do that. And by then it's too late. So be proactive, have good contracts. That's simple tip. Number 5, mismarketing. Marketing, it's obviously something that you have to do. It's something that every business needs to do, with limited exceptions. I mean, if you're surviving solely off of word of mouth, if you're one of the most popular restaurants in town where you really don't need to advertise, or if you're dealing with exclusively government contracts and you really don't need to market yourself, you just need to bid, then maybe this doesn't apply to you as much. But for all other businesses, especially customer-facing businesses, you got to market. And one of the common things that I see with my clients is they're stuck in an early stage of business development because they never hit milestones and never enter into a growth cycle where they can grow and expand because the clientele has never really grown with them. And a lot of that comes down to demand for services, but honestly, more of it comes down to marketing missteps. Your business needs revenue to survive. Revenue comes from customers and clients. They need to know about your business in order to patronize it, and they're not going to learn about your business unless you tell them somehow. And so marketing, um, good marketing, there's a few basic rules for it. You have a target audience. You don't want to just throw your marketing materials into the wind and hope it carries those materials to someone who has an interest in your business. You should have a sense of who you want to reach with your marketing efforts, because you only have so many ad dollars to spend. You only have so much money to spend on advertising. So you want to use it in the most effective way possible to reach the target audience that's most likely to bring revenue to your business. So you want to know who your audience is. You want to market to that audience, making effective use of your limited resources. Your advertisements should explain what your business does, who you are, and what you do. That might sound really self-explanatory, but I swear I've seen some advertisements where I had no idea who was behind the advertisement, what the business was, because they forgot to mention their own name, or they forgot to mention what they do. And it's not just about what you do, it's about how you add value. If we're talking marketing to other businesses, your services have to be a value proposition. You have to do something for them better than they can do themselves, or cheaper than they can do it themselves. And so your ads should relay that to some degree, or generate enough interest in the target audience so that they research your business and then figure out what the value add is. Your marketing strategy should grow your target audience over time, expand your reach, find new sources of revenue. So it should grow and evolve, and it should grow and evolve with the times, because, and this is another thing, and this is actually a little bit of hilarity. If you read legal rules of professional conduct, for example, they are very geared towards a form of advertising that is rarely, if ever, used anymore. They're, yellow and white pages and billboards are what those rules primarily regulate. But this is the year of our Lord 2021. We have search engines with business profiles. Not going to name them, but you know what they are. Social media websites, trade publications, review websites, affiliate marketing groups. There's all kinds of ways to market your business now. And a good marketing strategy looks at these all and makes effective use of all of them to varying degrees based on who you're trying to reach. And you really can't neglect the modern advertising mechanisms anymore, because by and large, people aren't even, it used to be, white pages and yellow pages. Then it was websites. Then it was finding your websites through social media, search engines. Then it was, finding your business profile that is separately set up on the search engine. Now it's social media presence and finding your social media pages. It's a combination of all of these things, and you can't neglect any of them if you're really trying to maximize your marketing potential. And so tip 5.1, constantly reevaluate and evolve your marketing strategies. And obviously, not everyone's a marketing expert, and you're not expected to be. To the extent you can do your own marketing, great. To the extent you can't, there are people whose sole purpose in the business world is to help other businesses market themselves. There's marketing consultants and firms. Some of them offer very different products and packages, whether on a flat rate or something per month, who knows? But the point is, there's tons of options, but there's this thing called marketing paralysis, where you don't know what to do necessarily, and so you do nothing. And that is the worst thing you can do. So take some time, figure out your options, and really take the time to fine tune your presence online and offline. Reach out if you need help. Again, the SBDC is a great resource that can point you in different directions. They're probably not going to do your marketing for you, but they can certainly give you some great counseling, and they can certainly point you in the right direction. They've got a wealth of contacts throughout the state of New Mexico. So maybe reach out to them if you're finding this whole process a little too daunting. They can definitely help get you where you need to go, one way or the other. And then finally, failing to plan for tomorrow or for today. And this is something that really sounds daunting for a lot of people, because if you're just starting your business, how do you know what you're going to need tomorrow? You might not even know what you're going to need today. But, and I say this, good businesses are going to plan for the short term. Great businesses are going to plan for the short term and long term. both, because it's not just about what you do today. If you have ambitions down the road to franchise, to expand internally to new locations, to sell the business, to get institutional capital and financing, investors, any of these other things, I mean, you have to really figure out what your ambitions and long-term goals are, and then you plan everything with that in mind, as well as your basic short-term needs. Hey, I need to get up and running. I need customers. I need money. If you can plan for both the short term and the long term, you're going to be really well positioned to execute on growth strategies. And so I'll give you a few examples here. There's this thing called qualified small business stock, where if you have a C corporation, not an LLC taxed as one, this is a big thing, a real C corporation, and your stock is worth under a certain amount when you get it, and you hold it for at least 5 years, and it qualifies under the laws, qualified small business stock, you can sell it and write off up to half the capital gains. Depending, it's a lot of depending in the tax code, but the point is, it can save you tons of tax money over what you might otherwise pay if you didn't go the qualified small business stock route. But that requires that you have a plan in advance to do that. Alternatively, you might go the S Corp route to minimize your Social Security and Medicare self-employment tax burdens, which requires you to look at your expected growth and revenue and really plan out how you're going to do this. If you're going to be taking on capital investors in a few years, you might want to get a head start by having a C Corp, because that's what they typically prefer. Same with leases. You know, you have to plan for today and for tomorrow. So don't sign a 10-year lease for a building you're going to outgrow in a year and a half. I have restaurant clients who literally can't grow because they are locked into a very burdensome lease for a space that is way too small to allow any kind of growth. So they're looking at second locations, but they're going to be tied to that first one for years to come. So the point of all this is just be thinking about what you want for this business and where you want to take it in 1 year, in 5 years, in 10 years, in 20 years, if you really want to go that far. But I mean, 10 years is probably a good sweet spot to focus on, because in 10 years, you'll obviously want to reassess based on how you've done the preceding decade. But plan for today, plan for tomorrow. The worst thing you can do is fail to plan at all, because then you're going in blind. But if you can think of some of these things that you might want to do with the company down the road, it's going to change how you set it up in the beginning. Got another question. Are you saying a C Corp is preferable to an LLC? There's not an easy answer to that question, because it really depends on what you want to do. But I am saying that in almost every case except one, a C Corp is preferable to an LLC taxed as a C Corp. If you want a different kind of taxation, whether that's S Corp, partnership, or disregarded entity, an LLC is probably going to be the best thing for you. But if you want the benefits of C Corp taxation or C Corp ownership, which are just beyond taxation, there's benefits to owning a C Corp, which I've covered in other webinars, and I'm sure I'll cover in a future webinar. But if you want the benefits of a C Corp, you have two options: a real C Corp or an LLC taxed as one. But because a real C Corp can do things an LLC can't, both in terms of qualified small business stock and in preferred shares, Class B shares, et cetera, stuff that investors really like, I'll almost never recommend an LLC over a C Corp. You know, an LLC taxes a C Corp over a real C Corp. So that's the kind of somewhat lengthy and rambly answer to that. Can you just switch your LLC to a C Corp at an appropriate time? And the answer is yes, you can, but it is not the easiest thing in the world to do. It's what's called an entity conversion, which New Mexico supports to a very limited degree. There's a lot of moving stuff. You might need a new EIN for the company, which would mean that you need new bank accounts. You might need to sign new contracts at that point. If some contracts don't assign, it's not the easiest thing in the world to convert from an LLC to a corporation. And so this is what I'm talking about when I say plan for tomorrow. If you know you're going to need a C corp for something in the near-ish to midterm future, maybe you want to just start with a C corp from the get-go, or maybe you don't because of the tax implications. It's important to think through these things, is I guess my point. So I kind of want to emphasize that you need to use your resources, because there's so many great resources at your fingertips, and you have the option obviously to use none of them. You can kind of go it alone, walk in blind, but there's so many resources that are free or low cost. I mean, the NMSBDC offers no cost business counseling, loan assistance, etc. Stuff that I as an attorney don't do. I mean, I just don't offer no cost counseling or consults. And so there's a lot of great resources out there that if you use properly, you're just going to have better outcomes. You're going to think through some issues that might not have been on your radar, and they're going to factor into your planning, which in turn means that you don't have to deal with them reactively as they crop up because you've already planned for them. And so you're going to have better outcomes, which means you're going to be able to grow your business better. Possibly, I mean, nothing's guaranteed in this world, but the point is you're going to have a better shot at it if you use your resources. So I cannot emphasize this enough. Highly recommend checking out what the NMS has to offer in terms of future workshops, no cost business counseling, and so on. It's just great resources that you shouldn't just leave on the table. Do I have any other questions from anyone? I want to make sure that I get to everyone's questions. We had a few minutes of interruption here. We might still end on time, but if you have any questions, please feel free to ask them now, because I'm sure we can go over a little bit.
Ian, I wanted to remind everyone, I know we kind of glitched a little bit, but I will be sending a copy of the slides out. So watch for that. We will have it pre-recorded on demand also, even with all the little technical things, but those will be coming to you.
Well, I just want to thank everyone for attending. If we don't have any questions, like I said, be sure to go to nmsbdc.org for further training, business counseling, and a number of other resources. I've got one more question. Oh, tax advantages for LLCs. Someone's asking what they are. And I'll keep it pretty surface level. I did kind of an in-depth primer on LLCs, which I'd encourage you all to go look at, by the way. It's the NMSBDC hosts prior webinars somewhere, so I recommend you go look at it. But the short version of this is that LLCs are very flexible vehicles. They can be taxed at your election as just about anything. If you have an LLC with only one owner, it can be taxed as a sole proprietor, which means you're just doing everything on your Schedule C, your personal tax return. It can be taxed as an S Corp or a C Corp, so you can get the benefits of those. If you have an LLC with more than one owner, it can be taxed as a partnership, an S Corp, or a C Corp. There's different pros and cons to each of those things, but the point with LLCs is that you have the choice of how you want them to be taxed. And so that's what I'm saying with LLCs taxed as C Corps. You can have an LLC taxed as a C Corp. And if that works for you, whether for anonymity or some other purpose, great. But typically for the reasons people want C Corps or C Corp taxation, a real C Corp is going to be better. That's about as much as I can really get into on LLC taxation with the time we have, but I'd encourage you to go look at the prior webinar. I think Leslie can speak to where they are or how you could find them.
Yes, I am going to send everyone in the follow-up email a link to our YouTube channel. What we do is we put the webinars, once they're live, we put them up on our website for 7 days after the webinar to view. After the 7 days, we add them to our YouTube channel. So we have all kinds of webinars posted on YouTube, and you can watch it. I'm going to send you the exact title. Ian, I think I think we did that last month, but I'm going to find that and I'm going to send the link directly to the LLC webinar so you'll have it. Also, there was another thing in the chat. Did you check? I will. Yep. And let's
Is there
see.
something in chat?
Thanks for the information, informative and resourceful presentation. Thank you so much.
Thank you all.
All right. And you're the host, so whenever you're ready to.
I will end this as soon as I figure out how, which would be right now. You all have a good rest of your day. Bye.
Thank